when we talk about the SS-1, it's the Secretarial Standards Board of Meeting. So we'll have a quick run through for the Secretarial Standards. So it has been approved by the central government, and half of the section of 173, 174, 175 has been repeated here. So 173 is about the board meeting, 174 is deal with the quorum of board meeting, 175 is resolution by circulation. So this standards provide for the board meeting convening and conducting the meeting of board, and it is also applicable to the committees, and there is an exception, the for OPC and section 8 companies. Then moving forward, whenever there is an inconsistency between secretarial standard and the act, always the act will prevail. So some kind of definition with respect to act, articles, calendar year, which should be considered and which are used in the secretarial standards are hereby given. So when we talk about the secretarial standard authority, who may call an board meeting? Any director at any time can call a board meeting. Then the chairman can adjourn the meeting. And if there is quorum properly present, and then also the director's object so whenever the chairman may dissent or object, whereby majority of directors may adjourn the meeting. So the notice of the board meeting should contain the date, time, place where it should be held, mode and serial number. Every meeting should have a serial number. The meeting can be held anytime, any place, anywhere. And next is the short has been given for the board resolution for the electronic voting, and the board meeting can be held on national holiday also. So the director may participate to electronic mode, but he can not attend the meeting by electronic mode by approval of annual financial statements, board reports, prospectus, and matters relating to amalgamation, merger, demerger, acquisition, and takeover. So there is an amendment here whether the physical quorum is present. If there are 2 to 3 members, 2 to 3 directors present in the board meeting, and others are present to video conferencing, the physical quorum is present, so other directors can be there through electronic voting. So next is the notice. Notice should be given to every director by hand, by speed post, to the address which is being registered with the company, and if the director's notice has not been given, then it shall, and if it is not on the default of the company, then it is valid meeting. And then the director may intimate about that electronic mode in the calendar year in the beginning also, and if he wants, he can attend physically after giving such notice. Then the notice shall be given on even if the meetings are decided that it should be conducted on 1st January or 1st June or any time between the predetermined dates. The notice shall be given at least 7 days before, or unless the articles provide some bigger date, and 2 additional days should be added when notice is given by speed post or registered post, and notice of an urgent meeting shall be given to all directors who did not vote, who did not attend the original meeting, and the notice can be less than 7 days of such urgent meeting. The agenda should be given by the with the notice at least 7 days before, and here also the same has been repeated that notice shall be sent to the director by his convened mode, and additional 2 days should be added. And here one point has been added: if the agenda contains an unpublished private information, then the notice can be of shorter period with the majority of directors, and if there is any one independent director, then with the consent of him also. Then the unpublished private information, the definition has been added from insiders trading definition: financial results, dividend, change in capital structure, merger, demerger, acquisition, changes in KMP, material events, and then the concept of each item of business requiring approval. When we send any agenda, then the draft of the resolution should also be sent, and each item of the business should be serially numbered. Any item which has not been included in the agenda can be taken up by the permission of the chairman and with the consent of majority of directors. To transact urgent meeting, notice, agenda and notes can be given at a shorter time. At least one independent director is present, and only at the rectification it will be considered. Then the frequency of meetings: at least 4 board meetings in each calendar year with a maximum interval of 120 days, and any 2 consecutive meetings. And if in the case of OPC, small company, dormant company, each half calendar year 1 meeting, and the gap should not be more than, and it should be not less than 90 days. Yeah. Meeting of the committees as the law prescribed, or this standard can also be applicable on it. Meeting of independent directors, independent directors meeting should have at least, they should meet at least once in a year, calendar year, and they should review the performance of non-independent directors, board, chairman, and the flow of information. Then the quorum shall be present throughout the meeting, and not only at the time of the commencement but while transacting. The director shall neither reckon for quorum nor shall be entitled to participate. However, in a case of private company where a director is interested, he can participate after disclosure of interest. And when can a director can be considered as interested? When a company is entering into a body corporate, and in that body corporate the director is having holds with other directors 2% or more of the paid up capital, and is a promoter, manager, CEO of that company, of that body corporate, a firm from which a company is entering into an arrangement or contract, and that director is a partner, owner, or a member. Next is the item of business, the related party transaction, then it should not present at the meeting whether physically or through electronic mode during discussion and voting on such items. The directors participate through electronic mode in a meeting shall be counted for purpose of quorum. The quorum for the meeting should be 1/3 of directors or 2, whichever is higher. 1/3 is 100 of the next, and the quorum requirement, if higher in the articles, then you should adhere to such quorum. And if the interesting directors exceeds 2/3 of the strength or is equal to 2/3, so the minimum quorum should be 2. And if there is no quorum, then the meeting shall get adjourned to the next day, same day, in the next week, at same time, same place. And same place is not necessary, but next is, if then even in the adjourned meeting the quorum is not present, then the meeting gets cancelled. Number of directors reduced below the minimum fixed by articles, then the number of directors can come together and arrange a general meeting or a board meeting for increasing the number of directors and for not any other purpose. The meeting of committees. Which is stipulated in the act or the articles of the law, the board may be specified. The meeting of the committee may be specified by the board, the quorum. Next is the attendants. Shall maintain an attendance register which shall be serially numbered. Then the details of all the directors, and even for the committee meetings the register should be maintained, and even the electronic record should be maintained and should be authenticated by CS, or if there is no CS, chairman, or by any other director if he authorized. And when directors are participating to electronic mode, he shall take a roll call who is present, that he should request the other directors who are present through electronic mode to tell full name and the location. Next is the attendance shall be maintained at the RO and or such other place has been approved by the board. It is open for inspection by directors, and no member, this is an important point, member of a company is not entitled to inspect the attendance register. Attendance register shall be in the custody of company secretary, or where there is no company secretary, any other person has authorized by the board. Leave of absence shall be granted to a director which has been communicated to the company secretary or chairman or to any other person authorized by the board. A place of a director becomes vacant when he himself absents from all the meetings of the board with or without seeking leave of absence. Chairman. Meeting of the board. The chairman of the company shall be the chairman of the board. If the company does not have a chairman, the directors may elect among themselves. The chairman shall conduct the board. If the chairman is interested, he shall leave that meeting and then again resume the chair. In case of private meeting company, chairman can continue after his disclosure. Related party transactions, business, item of business is related to related party transaction, he cannot transact or participate. And the chairman should take reasonable care for the integrity and ensuring security that the electronic mode of meeting is being properly held, and he should also ensure that the quorum is present throughout the meeting. And even the articles, unless prescribed, the chairman shall have a second or casting vote. Meeting of committees, it should be as prescribed by the act or board or the articles. Passing of resolution by circulation. There are certain businesses which cannot be held by circulation, which has been given in the annexure. Authority, the chairman of the board or MD, or in absence any director other than interested director, before draft resolution is circulated, approval of the board for a particular business shall be obtained by means of circulation. 1/3 of the directors, total number of directors, tell that this resolution be taken in the proper convened meeting. Then it should be taken in the meeting itself, and in that 1/3 interested directors are also counted. What is the procedure? A resolution to be passed by circulation shall be sent in draft together with the necessary papers to all the directors, including the interested directors, on the same day. The draft of the resolution to be passed and necessary papers shall be circulated among the directors by hand by speed post or by registered AD or by courier or by email. And that address should be from the director's address which has been registered by the company or from the DIN. And it's a proof of such sending and delivery should be kept at for 3 years. The resolution by circulation shall explain by a note the details of the proposal, the relevant material facts, the director so that the directors can understand the scope and nature. Each resolution shall be separately explained. Not more than 7 days from the date of circulation shall be given to directors to respond, and last date shall be computed accordingly. And additionally 2 days shall be added for the service given by speed post or registered approval. The resolution is passed when majority of directors are entitled to vote, unless 1/3 of the total number of directors require that resolution to be passed in the meeting. Each resolution shall carry a serial number. If any special majority of affirmative vote of any director or specified in the articles, the resolution shall be passed only with that assent of such majority, special majority. Interested director shall not be entitled to vote. And the interested director, the same definition has been given when the company is entering into a contract or arrangement with the body corporate, and if such director is holding with other directors is holding 2% of the paid up share capital, or is the promoter, manager, CEO, then, and if there is a firm and the director is a partner, member, owner, if the resolution is, if passed, shall be deemed to have been passed on the earlier of when the majority last date specifying for assent has been given and the required majority has been provided, and the requirement of board meeting and the requirement of the matter to be taken up in the board meeting is not more than 1/3 of the total directors requiring it, shall be effective from that date. The director shall append a date, and if there is no date, the date of receipt shall be taken as the date of signing. And the interest of director has not been communicated, then the interest before the last date specified for the response shall be given. And even if the director does not respond, it shall be presumed that director has abstained, and approval of majority of the directors has not been received, then the resolution is considered as not passed. Recording, a resolution passed by circulation shall be noted at a subsequent meeting with the dissent and assent, and it should be recorded. Validity is it shall be considered as has been passed at the duly convened meeting, but this does not dispensing the requirement of having a board to meet at specific frequency. Minutes, every minute company shall keep a minutes of board and committee meetings, and because it is an evidence of proceedings recorded therein, the maintenance of minutes shall be recorded in books, and distinct minutes book shall be maintained. It shall be in physical form or in electronic form. The pages shall be consecutively numbered. It shall not be pasted or attached, loose leaf form, and in coinciding with one or more financial years of the company shall be kept at the RO or at any other place as may be approved by the board. Contents of the minutes. General contents at the beginning, serial number, type, name of the company, date, day, venue, and time of commencement. In respect of meetings adjourned for want of quorum, a statement to the effect shall be recorded in the minutes. It shall record the name of the directors present and the people who have taken leave of absence, and even the invitees for specific items shall also contain a record of all appointments made in the meeting, name of the directors who are present, their mode, then the location from their appearing in the electronic mode, the name of company secretary and invitees, record of election, record of presence of quorums, the name of directors who sought and were granted leave of absence, noting the minutes of the preceding meeting, noting the minutes of the meetings of the committees, the text of resolution passed by circulation, the fact that an interested director did not participate in the discussion, and the view of directors, particularly the independent director, has participated only for a part of a meeting, the fact of dissent and the name of director who dissented from resolution, rectification by independent director in the case of meetings held at a shorter notice, consideration of any item other than those included in the agenda and which has been rectified by majority of directors, the time of commencement and conclusion. Apart from the resolution or decision, minutes shall mention the brief background of all the proposals, deliberations, and the major decisions. Recording of meeting. It shall be a fair and a correct summary of the proceeding of the meeting. It shall be written clearly and concise and in a plain language so that the third person can understand. And whenever the minutes are written in the past tense and resolution are in the present tense, it should not be the exact transcript, but many directors are of view that it should be added. It is a discretionary power of the chairman whether to add it or not. Wherever the decision of the board is based on an unsigned document, such which were not part of the minutes, it shall be referred in the minutes. Part of the notes, it should be referred in the minutes. When an earlier resolution or decision is superseded, it should contain a specific reference to such earlier resolution or decision. Minutes of the preceding meeting shall be noted. Finalization of meetings within 15 days from the date of conclusion. The draft minutes shall be circulated by hand, speed post to all the members, and then the draft minutes and its delivery shall be maintained for 3 years, the proof of service. If any in writing on draft minutes within 7 days from the date of circulation, they should communicate their comments and the chairman should consider it. And if they do not comment, then it is being deemed approval. Entry in the minutes book within 30 days from the conclusion shall be recorded by the company secretary. Once entered in the minutes book shall not be altered. It shall be signed and dated by chairman of the meeting or by chairman of the next meeting. Shall initial each page of the minutes. Last page. Each page of the minutes, sign the last page. Date on which and the place where he has signed the minutes. Once signed by the chairman cannot be altered. Within 15 days of signing, a copy of said minutes shall be certified by the company secretary and it shall be circulated to all directors except who had waived their right to receive, and such waiver is required in the minutes. Inspection and extract of minutes. A director is entitled, if a director ceases, he is entitled to see the minutes of his period of his directorship, and a member is not entitled to inspect that minutes book. Extract of the minutes shall be given only after the minutes have been duly entered in the minutes book, and certified copies of the resolution passed may be issued earlier if the text of that resolution had been placed at the meeting. Preservation of minutes and other records. It shall be preserved permanently, and if the transfer company has been amalgamated with a transferee company, then the transfer company minutes shall be preserved permanently, Office copy notes, agenda notes, and agenda notes on agenda shall be kept for an 8 years. The minutes book shall be kept in the custody of company secretary. The disclosure, the report of the board of directors shall include a statement on compliances of applicable secretarial standards. Illustrative items which shall not be circulated, passed by circulation. Audit committee noting approval of financial statements, compliance certificate, list of laws applicable to the company, appointment of secretarial auditor, internal auditor, borrowing money otherwise by issue of debenture, investing the fund, granting loans, making political contribution, call on shareholders, remuneration of MD, whole-time director and manager, appointment or removal of KMP, appointment of a person as a MD manager, public company, appointment of director in casual vacancy, related party transactions, sale of subsidiaries, purchase and sale of material, tangible, intangible assets, approve payment to director, items arising of separate minute, authorized buyback, issue of securities including debentures, amalgamation, diversify the business, takeover, approve annual operating plans, capital budget, remuneration, show cause demand, prosecution notices and penalty notices, serious accidents, material default and financial obligation, any issue which have a negative implication, details of joint venture, substantial payments, significant labor problems, quarterly details of foreign exchange exposure, non-compliance of any regulatory, statutory or listing requirements. The agenda for the first meeting of the board should be to appoint the chairman, note certificate of incorporation, memorandum and articles, to note the situation of RO of the company, to note the first directors of the company, to record any notice of the disclosure of interest, appointment of additional director, chairman, first auditor, common seal, bankers, and to open bank accounts, share certificate, issue of share certificate to the subscribers, approve and rectify preliminary expenses, preliminary arrangements, and to approve the appointment of KMP.